Welcome to Points of Interest, a video series brought to you by the Investor Protection Clinic at Osgoode Hall Law School and sponsored by the Law Foundation of Ontario. After suffering an investment loss or harm due to misconduct, investors may consider initiating a lawsuit against the investment firm and/or the advisor responsible. However, the civil litigation process can be costly and complex. This episode will explore the various levels of court, as well as provide you with some helpful considerations and alternatives to help you determine whether civil litigation is right for you and your claim. For investors who have suffered an investment loss or harm due to misconduct of a firm or advisor, pursuing civil litigation is one way to obtain a remedy. Civil litigation is a non-criminal dispute between two or more parties where a plaintiff initiates a lawsuit against the defendant in an effort to recover compensation or other forms of damages. While legal representation is not required for litigation at all levels of court, it is often recommended. This is because the intricacies of civil procedure can be complex, and lawyers who practice in litigation matters are most familiar with court procedures and what documents need to be filed at each stage of the process. There are two primary levels of court in which an investor plaintiff can file their claim. These include provincial and territorial superior courts and small claims courts. While the discussion in this episode will primarily reference the law and procedure in Ontario, many of the concepts will be applicable across other jurisdictions in Canada. It is important to keep in mind that plaintiffs do not necessarily have a choice between which level of court to use in their suit. Determining which level of court applies to a plaintiff's claim will largely be dependent on the form and value of the remedy sought. For example, small claims court is not available where the plaintiff is seeking the return of property. Understanding what remedy you're looking to recover as a plaintiff, and understanding whether the remedy is realistically attainable through civil litigation is crucially important when considering filing a lawsuit. Suing an individual who is unlikely to have the funds to pay a court award, or suing an individual who cannot be located, may suggest that the time and cost of a lawsuit is not worthwhile. Let's now take a closer look at the courts, their specific procedures, and particular compensation limits. The Superior Court of Justice is the trial-level court in Ontario. The trial-level courts are where civil claims typically begin. If either side questions the decision made by the Superior Court of Justice, the claim may go to appeal, which would then be heard by the Court of Appeal in Ontario. Civil proceedings in the Superior Court are governed by the rules of civil procedure unless otherwise stated. The rules of civil procedure require the use of a set of prescribed forms which are linked below. Generally, a civil claim has 6 steps. 1. The plaintiff brings the claim by filing a statement of claim. 2. The defendant prepares a statement of defense to defend the claim. 3. Discovery occurs. Discovery can include both a documentary review and an examination. 4. The action is set down for trial and a date is fixed. 5. The parties attend a pre-trial conference before a judge to try and settle the case or narrow the issues. 6. The trial occurs. Note that where parties file a claim in Toronto, Windsor, and Ottawa, they are subject to mandatory mediation pre-trial. Also, where a claim is for money or property valued between $35,000 to $200,000, the claim can be started in the Superior Court of Justice using a simplified procedure. For more information on these processes, visit the links below. The Small Claims Court is a branch of the Superior Court of Justice which an investor plaintiff could use if the remedy sought is monetary compensation valued at $35,000 or less. Small claims court proceedings in the Superior Court are generally governed by the rules of the Small Claims Court. The rules of the Small Claims Court require the use of a set of prescribed forms for small claims court proceedings, which are linked below. The rules provide for a streamlined procedure which allows cases to be determined at a lower cost and in less time than those started in the Superior Court. In Small Claims Court, whether you are able to appeal the court's decision is determined based on the value of the judgment. If the judgment is for less than $3,500, neither party has a right to appeal. However, if the judgment exceeds $3,500 in value, the Divisional Court, a branch of the Superior Court of Justice, may hear the appeal. One notable difference of small claims court is that there is no opportunity for discovery. Only documentary discovery is disclosed to the other side prior to trial. Additionally, filing fees are less expensive than fees for Superior Court, and small claims court trials are simplified and typically last one day. Now that you've been introduced to the courts in which you could file your claim, we will discuss some procedural considerations which may have an impact on your decision to pursue a remedy through civil litigation.
My name is Susan Kushnerick, and I am a partner at the law firm Kushnerick Morgan LLP. There are two key considerations investors should be mindful of when deciding whether to initiate a civil action. The first consideration is the investment contract between the investor and the investment firm or advisor. The investment contract may stipulate what dispute resolution mechanism an investor must use to pursue a complaint or seek relief. For example, the investment agreement may contain a mandatory arbitration or mediation clause. This would mean that an investor would be obligated to follow the dispute resolution process specified in the contract, and they may not be able to pursue a civil action. Before taking any steps to pursue a civil action, investors, and their representative if applicable, should review the investment contract and see if it requires the investor to use a specific dispute resolution process to resolve their complaints. The second and equally important consideration is the remedy the investor is seeking and whether civil litigation is an appropriate mechanism to achieve that remedy. Investors need to determine if the proposed level of court has the jurisdiction to grant the remedy they're seeking. For example, if the investor is seeking a return of property or compensation in an amount above $35,000, then they would be unable to seek relief through small claims court. Instead, they would need to pursue their claim in the Superior Court of Justice. Since litigation can be extremely expensive, investors should also consider whether they can obtain the same remedy using a free or less expensive alternative to civil action. Finally, if the investor is not seeking compensation, litigation may not be appropriate. For example, if the investor is more concerned to seek disciplinary or regulatory action, it may be more appropriate to complain directly to the local securities regulator or a national self-regulatory organization like IROC. Investors should be aware of the relevant statutory limitation period for their province or territory when deciding whether to pursue civil litigation. The statutory limitation periods differ from province to province and provide time limits as to when claimants can launch a civil action. In Ontario, for example, the Limitations Act sets a general limitation period of 2 years for civil claims to be commenced. This means that investors must file their claim within 2 years from the date when they knew or reasonably ought to have known of the events giving rise to the harm or loss. You may wish to seek legal advice to gain a more in-depth understanding of these time limits and the impact they may have on your decision to pursue civil litigation. Limitation periods mean that it's really important for investors to act quickly when they become aware of possible wrongdoing. Once a limitation date is missed, a claim is barred from proceeding in the court. When pursuing a civil action, investors need to be able to produce evidence that can substantiate the misconduct or mismanagement that they allege. Evidence can include the investment contract between the investor and the investment firm or advisor, copies of statements, know your client or KYC forms, any form of communication or correspondence between the investor and the firm or advisor, as well as any other document that the investor believes assists them to prove their claim. This is why it's important that investors keep copies of these documents in an organized and easily accessible manner. Investors are not required to have legal representation at all levels of court, though it's often recommended. This is because investment disputes and matters involving civil procedure, they can be quite technical and complex. If you're not sure whether you can afford a lawyer, you should consider whether you qualify for legal representation from a pro bono legal clinic or whether you qualify for your local legal aid program. If you're unable to find a lawyer with experience in civil litigation or one with knowledge of the investment industry and Canadian capital markets, you should inquire if the regulatory body that oversees the legal profession in your province or territory has a lawyer referral service. For example, Ontario residents could consult the Law Society of Ontario Lawyer Referral Program. Mediation is an informal process in which a neutral third party helps participants reach their own agreement to resolve a dispute. The rules of civil procedure have made mediation mandatory for all disputes taking place in Toronto, Ottawa, and Windsor. Investors bringing claims in those jurisdictions are required to attempt to resolve their dispute with the investment firm or advisor through mediation prior to trial.
There are three main cost considerations investors should be mindful of when deciding whether to pursue civil litigation. 1. It can be quite expensive to pursue a civil action. Retaining a lawyer from the time that the investor files a statement of claim through to judgment and any appeals can be costly. On top of legal fees, there are administrative and filing fees associated with commencing a civil action. In some cases, the significant cost of pursuing civil litigation can outweigh the potential amount of compensation a harmed investor may receive. 2. If the investor is unsuccessful at trial, they may be responsible for some or all of the investment firm or advisor's legal costs. Note that costs tend to be far more substantial in superior court than in small claims court. There may also be cost consequences where the incorrect court procedure was used. For example, there may be adverse cost consequences for the investor where they pursued their claim through the ordinary procedure, and the court determines that the simplified procedure would have been more appropriate. 3. Rejecting a written offer to settle can have significant cost consequences. Rule 49.10 of the Rules of Civil Procedure impose a cost consequence on a party who rejects a written offer to settle, where the party that made the offer to settle obtains a result at trial that is as favorable or more favorable than the written offer. Whenever an investor is presented with a reasonable written offer to settle, they should consult their legal representative on how to proceed and the potential cost consequences of rejecting such an offer. Alternatively, there may be a cost benefit for an investor who presents an investment firm or advisor with a reasonable written offer to settle in advance of trial. If an investor is unsuccessful at trial, the decision is final and legally binding, subject only to any right of appeal the investor may have. Further, obtaining a judgment through a civil action will disentitle an investor from pursuing a remedy through an OBSI investigation or the IROC arbitration program. This is why investors should consider all their dispute resolution options before taking steps to initiate a civil action. Pursuing a civil action does not disentitle an investor from complaining to a governing SRO or provincial and territorial securities regulator. The SROs and local securities regulators have the jurisdiction to oversee the Canadian capital markets and pursue disciplinary action where necessary, independent of and regardless of any civil claims between relevant parties. As a separate and distinct process, civil litigation grants investors monetary compensation where claims are proven, whereas SROs and securities regulators pursue disciplinary and regulatory action in the form of fines and suspensions, not compensation for investors. With these procedural considerations in mind, you may find that some of the alternatives to the civil litigation process might be the most effective avenue to pursue your claim. Civil litigation is often referred to as a remedy of last resort, meaning investors should consider pursuing all other forms of dispute resolution before launching a civil action. In most cases, the first step to resolve an investment dispute is for the investor to complain directly to the investment firm or advisor. Most Canadian financial institutions and investment firms have internal dispute resolution processes to resolve complaints. If you are not satisfied with the solution proposed by the firm or advisor, you can escalate your complaint. If the firm is a member of the Ombudsman for Banking Services and Investments, or OBSI, you might want to pursue a complaint through their free dispute resolution process. Even though OBSI only issues non-binding recommendations, they have an excellent track record of resolving disputes. For more information on OBSI's dispute resolution services, please see episode 4 in the Points of Interest series, Navigating the OBSI Complaint Process. Alternatively, the Investment Industry Regulatory Organization of Canada, or IIROC, offers an arbitration program for investors to seek compensation against member firms and advisors. The parties will appoint an arbitrator who will issue a legally binding decision to resolve the dispute. While there is a cost for using this arbitration service, IIROC arbitration is still less costly and less time-consuming than court. For more information on the IIROC arbitration program, please see the Points of Interest episode, Navigating the IIROC Arbitration Program. If you are not interested in financial compensation, but instead would rather pursue regulatory or disciplinary action, such as having fines and suspensions imposed against investment firms and advisors, you might want to consider submitting a complaint to a self-regulatory organization like IIROC or to your local securities regulator. Civil litigation is only one of the many dispute resolution mechanisms available to retail investors to resolve their dispute. Be sure to consider all of your options before commencing a civil action. You may want to consider obtaining legal representation to ensure you select the right dispute resolution mechanism for you and your claim.
As we bring this episode to a close, here are the key points of interest from Is Civil Litigation Right for You and Your Claim? 1. Determining whether civil litigation is appropriate or which level of court applies to a plaintiff's claim is largely dependent on the form and value of the remedy sought. If an investor is seeking disciplinary or regulatory action only, it may be more appropriate to complain to the local securities regulator or a national self-regulatory organization. 2. The remedy or the amount of compensation claimed by an investor will impact the level of court and type of proceeding used. Claims for compensation of $35,000 or less should be brought in small claims court. For claims between $35,000 and $200,000, investors should pursue their claim using the simplified procedure. And for claims valued at $200,000 and over, the ordinary procedure in the Ontario Superior Court of Justice is most appropriate. 3. Each province and territory imposes a general limitation period by which parties must commence a civil action. In Ontario, claimants have 2 years from the date where they knew or reasonably ought to have known of the events giving rise to the harm to commence a civil action. 4. The cost of pursuing a civil action can often be prohibitive for many investors. Further, investors should be mindful of the possibility that they may be responsible for some or all of the other parties' legal costs if they are unsuccessful at trial. There are adverse cost consequences where an investor seeks relief through the wrong level of court or rejects a reasonable written offer to settle. 5. There are many alternatives to litigation that are less costly, less time-consuming, and less formal than commencing a civil action. Before taking any steps to pursue a civil action, investors should consider whether it is possible to obtain the same remedy using one of the free or less expensive alternative dispute resolution mechanisms mentioned in this video.
The Investor Protection Clinic at Osgoode Hall Law School acts for investors who believe their investments have been mishandled and who cannot afford legal representation. The Investor Protection Clinic is the first clinic in Canada to offer free legal advice to retail investors. If you have any questions about the IPC's services, this episode, or any other episode in the Points of Interest series, please feel free to contact us.